This morning's topic is light touch administrations, and particularly the protocol that has been set up for light touch administrations. What I want to talk about is why we have this protocol in the first place as a reason for light touch administrations. What's different about a light touch protocol administration by comparison to any other type of administration? I want to talk about the statutory purpose of administration and how that works in a light touch procedure. I'll also do a quick compare and contrast to look at what other procedures you might be considering when it might be appropriate for you also to think about a light touch administration. There's then a big but in all of this, which is the views of the regulators that I will want to talk about, and a bit, however, which is the reaction of this, which is also worth talking about. And finally, I want to finish by my own thoughts about whether we as practitioners are actually likely to use the light touch protocol. So it dates back to 130 years ago, March last year, when we had the first lockdown. We had enforced business closures, and we had staff being sent off on furlough, which was then a completely new expression and a new concept for us. We had businesses then that we could see were almost completely closed or totally closed, minimal trading, and yet there seemed to be a real chance that those businesses were fundamentally sound, and at the end of the lockdown period would still be able to survive as a going concern. And there was a lot of talk in the profession at that time about the need for a lightweight debtor in possession procedure, something that would allow the management to continue in control of their business. Desirable, I suppose, because it's easier to persuade people to put their business into administration if they've got more control over it. And secondly, because the sorts of businesses that we saw being mothballed then were businesses that seemed to be fundamentally sound. They actually had good management and a sound business model. It was just external circumstances that was knocking them over at that point. As always with a debtor in possession procedure, of course, the greater involvement of the management does result in greater stakeholder risk. So that was the reason for developing the protocol. It was built upon the existing statutory administration procedure as being the most sensible foundation for it. And it was put together by a bunch of very eminent practitioners, including Mark Phillips QC, the Insolvency Lawyers Association, and the City of London Law Society. And I'll just say at this stage, I was not involved in any way with developing the protocol, so my views on it are completely independent and disinterested in that sense. It was used very early on in a high-profile case, the Debenhams administration order. Now, unfortunately, Debenhams lost its concessions when Arcadia, who were a major subtenant of it, themselves went into administration. Knock-on effect of that was they don't have a buyer for the business, and as a result, Debenhams has gone into liquidation. But the unfortunate result of that administration is not a consequence of using the lightweight procedure. It is a consequence of other events. The next thing I want to look at is what's different about a light touch administration and what's different about the protocol. And it's built upon a standard administration. The protocol does envisage that the appointment would be by an administration order in open court. And on balance, under present circumstances, I think that's probably still sensible. I'll talk about that in a bit more detail later. And the protocol also envisages that the statutory purpose for which the protocol should be used is to rescue the company as a going concern. I don't think that's essential, but it's certainly consistent with the background to which the protocol was developed of mothballed businesses that fundamentally had good quality management and a sound business model. The main element that the protocol is built upon is paragraph 64 of Schedule B1, which gives the administrator the power to consent to the director's powers continuing in the administration. And I will emphasise that a bit later on as well, that this is not a delegation of powers back to the directors. This is simply the administrators stepping back from involvement in certain aspects of the business and allowing the directors who were dealing with those issues pre-appointment to carry on dealing with those issues post-appointment. The protocol does also envisage, and this is of course very important, it does envisage a clear definition of the powers that the directors are going to be allowed to exercise. There is a template document that sets out what those powers are, and I'll be putting a copy of that on the Frettens website after this, so that you can download it from there if you haven't already got a copy that you want to look at. The protocol is built upon a standard administration. As I said, it envisages an appointment by a court order. That is not essential, and I think it would be possible to run a light touch administration with an out-of-court appointment of administrators. But I think you'd need to think quite carefully, and I think you should start by thinking about this being kicked off with a court administration order, and you might decide after review of everything that that's not necessary, but I think that should certainly be the starting point. I've talked about paragraph 64 as being fundamental to this and the restoration of directors' powers. The key concept in paragraph 64 is the idea of a management power. And a management power is anything that could interfere with what you might want to do as administrator. And the general rule is that once the company has gone into administration, the officers, which include directors and other members of the management, the directors cannot exercise a management power without the administrator's consent. So they can't do anything that could interfere with your conduct of the administration. But paragraph 64 does expressly envisage that administrators may allow the director to carry on using their pre-existing powers. So in effect, administration doesn't remove directors' powers, it simply suspends them, and you've got the right to unsuspend them. And that consent can be either general or specific. It might be just for a single occasion in a particular way, or it could be a general restoration of powers to cover a wide area of activities, which is what is envisaged in the protocol. So the template protocol itself, as I said, it envisages that the business, the company, will be rescued as a going concern. That will be the objective that the administrators will be working towards. It does also envisage that you will need to check that the company has enough working capital to pay administration expenses as they fall due. I mean, that's essentially a requirement for pretty well every administration, and particularly one where there's going to be any level of business activity, any degree of trading at all. And it also requires regular and specified reporting from the management to the administrators and monitoring by the administrators of what the directors are doing. It restores power to the directors broadly to trade the normal conduct of the business within specified limits. Now, in the case of a mothballed business, those limits would actually be extremely tightly drawn, but I can see circumstances when you might actually widen it up a little more than that. Crucially, the template also does keep the rights of the administrators at any time to step in and take over and to withdraw their consent, to say to the directors, sorry, game over, we can't carry on like this, we're going to have to take charge from now. The template does also envisage that there will be an exit to the administration through a voluntary arrangement or a Companies Act scheme of arrangement, or some less formal settlements such as a turnaround agreement or other agreement with the key stakeholders. So it does look to some sort of mechanism for transitioning the power back to the directors completely at the end of the administration. The statutory purpose, as I said, the protocol does envisage rescue of the company as a purpose, and exit through something like a CVA, some sort of compromise scheme. I don't think that's essential, and I do think it would be possible to run a protocol light touch administration that is intended to realise assets either beneficially for the creditors or specifically for the benefit of secured creditors or preferential creditors. And there's a couple of examples in the law reports of cases which have been done on that wider basis. Debenhams, for example, the administration was clearly being run with a view to getting a better result for creditors, sale of the business as a going concern, and nobody seemed to have a problem with that. And there's also the case from a couple of years ago, Davy and Money, which was one where the director of the company challenged through the courts the way that the administrators had conducted the administration. And that was described, it's a pre-protocol administration, so it wasn't a protocol light touch administration, but it was described in court as a light touch administration, by which they meant that the administrators had heavily subcontracted a lot of the work to carefully chosen agents, and were letting them get on with a lot of the work that administrators might otherwise do themselves. And the courts had absolutely no problem with that whatsoever. And in fact, they regarded it as quite legitimate for administrators to delegate their power to somebody who could do it more efficiently than they could, or at a lower cost than they could. So let's look at the sorts of procedures that you might be thinking about when you might want to also add a light touch administration to the list of options. And you should be thinking about a light touch administration, not just as a straight protocol light touch administration, but the protocol itself can be quite heavily modified to the needs of the particular case. You could think about something that's rather broader than that. The sort of situations you might be thinking about might be a straightforward administration of a more conventional sort. You might be thinking about perhaps setting up a pre-administration moratorium for an extended period, either by applying to court for an administration order or by filing a notice of intention to appoint. And these can sometimes go on for a little longer than the statutory procedure envisages. If you are going for an extended pre-appointment moratorium period, it's probably better to do that in the context of a court application for an administration order, and to look to adjourn the main hearing itself. But there are circumstances when that might be the right thing to do. You might be thinking about one of the new style moratoriums from Part A1 of the Insolvency Act, the Corporate Insolvency and Governance Act procedure. Or you might be thinking about a CVA, and R3 of course have their own COVID-19 template for lightweight CVAs. Now we come to the big but, the regulators' views. And I have to say, I'm slightly disappointed by this because the Institute in particular were very unenthusiastic about the light touch protocol. Now, context behind this, I think, is that the protocol was published fairly early on in lockdown 1. It was at a time when the government were promising new corporate debtor in possession procedures in a new insolvency bill, but that hadn't been published. And I suspect there was possibly a bit of politics with the Institute being aware of the need not to be seen to be apparently undermining a new procedure that the Insolvency Service was about to steer through Parliament. So there were some concerns published at the time. They're quite difficult to find, but I couldn't find them at all on the Institute website when I was putting this together. But essentially what the Institute were worried about was the power that directors might have in a case like this. They were worried about possible gaps in the template. They were worried about how practitioners might be able to assess the character of directors in current circumstances when it's not easy to meet the directors face to face. And they were worried about the risks to the insolvency practitioners concerned, both legal and regulatory. And just to emphasise the regulatory risks, they did say that monitoring visits will look particularly at the level of insolvency practitioners' control and oversight in any such cases. Now, dealing with those concerns item by item, the first one is about the power that the directors themselves might have. And I think there's been quite a lot of misunderstanding about the light touch protocol and the way it works. It's not the delegation of powers from administrators to directors. It's not handing back of powers. It is simply the administrators circumscribing their own authority, limiting the area that they themselves will be involved in to allow the directors to continue to exercise their pre-existing powers in those particular areas. It's going to be important to define what the directors can do and to monitor what they're doing to make sure that they stay within the bounds of what is permitted and to make sure that the consequences of them exercising their powers are as expected. The Institute also were worried that there were gaps in the template, and there were points that they specifically covered, which included the issue of funding the administration and banking arrangements for the company in administration, health and safety issues, and GDPR, data protection, and other regulatory issues. Now, those are issues that I think are not unique to light touch administrations, either within the protocol or within the wider view of light touch administrations where administrators use third parties to do a lot of the work for them. These are issues that arise in pretty well every trading administration, unless you're actually doing a pre-pack and selling the business on day one. These are issues you're going to have to deal with, and I don't think they are unique to the light touch protocol. So I'm not underplaying the importance of them. They are important. They are issues you're going to have to think about pre-appointment and post-appointment, but they're not unique to protocol administrations. The issue about assessing the director's character, yes, again, that is, of course, relevant, but I think it's more important not what you think of the director on first impression of meeting them. It's more important what they actually do, how they actually behave when appointed. And I think that's something that you probably can cover with reporting and monitoring post-appointment. And the risks that you face as an insolvency practitioner, legal risks, well, they're not unique to light touch administrations. And as we've seen, the court's attitude to light touch administrations, both within the protocol or on other arrangements, is actually fairly favourable. And in terms of the regulatory issues, well, I'm sure that the Institute would not be holding administrators to a higher standard of accountability on a light touch administration than they would on any other administration. And yes, it is reasonable to look at the level of control and oversight, but those are issues which are going to be relevant to every trading administration that you get involved in. Now, the areas where I have seen across the board that the regulators do get particularly interested in administrations are the three Ps: pre-packs, phoenixes and private debentures. And if you've got one of those in the mix, then there's going to be a red light flashing on your dashboard anyway. And if you've got one of those involved, that wouldn't, I think, necessarily rule out a light touch protocol administration if it were otherwise appropriate. But you would certainly want to limit the director's powers very clearly to normal operational issues, and you wouldn't get them involved in any way with any of those three issues. Now, the other protections that I think would perhaps be important for you in the light of the regulators' concerns are, in many cases, I think it is going to be appropriate to appoint by an administration order. And the reason for that simply is that there is two additional levels of scrutiny and oversight. The first one is in preparing the court application, you're going to have to put much more down on paper than you otherwise would. And you're going to have to pass that across to my learned friend acting for you, who is going to look at it and is going to raise with you any concerns that they have got in terms of how they present the case to the judge and what issues they think the judge is going to be. So that's the first level of scrutiny. And the second level of scrutiny is, of course, the High Court judge themselves, who are going to look closely at why you are proposing to set up the administration this way, what controls and safeguards you're building into it, and you can expect a certain degree of scrutiny there as well. My view is it's generally better for the court to refuse to appoint you as administrator in a case where administration is not appropriate. That's better and safer than it is for you to steam in, get yourself appointed, and then get removed by court order afterwards, which is horribly messy, expensive, and inconvenient in all sorts of ways. The second protection that I think is important is with the monitoring and supervision that you're exercising, you actually need to be ready to pull the plug quickly if it goes wrong, and be prepared to do that and to be willing and able to do that. And the third thing, which of course is any extended insolvency procedure, is keep talking to the main stakeholders, let them know what you're doing, how it's going, what the plans are, and listen to their concerns and what they want out of it. In terms of the court's reaction, I've already mentioned the two cases of Debenhams and Davy and Money, where the courts actually seem, generally speaking, quite content with a properly run light touch administration, whether that be protocol or some other arrangement. The thing that the courts really don't like is where they see administrations being used as a tool to override legitimate interest, particularly stakeholder interest. This is particularly the case where you've perhaps got an internal dispute within the company over its control, its ownership, its management, something of that sort. And if you've got that in the background, then that is certainly a case where you ought to be looking, I think, at having a court appointment of an administration. And my general principle there, that if there is a dispute brewing anywhere in the context of an administration and there's any risk you could be drawn into it, it's better to go to court, ask the court to appoint you as administrator, and to let the parties to that dispute make their case in court before you're appointed, as being far safer than having you being drawn into somebody else's argument after the event. So the final point I want to cover really is, should we actually be using the light touch protocol or not? And there are a number of other procedures that I think you would be thinking about at the same time as you're thinking about a light touch protocol. The first one is the new statutory moratorium procedure. There's not been, as far as I can see, huge enthusiasm for this procedure, and I can understand that. There are two concerns I've got about it. The first one is the extremely narrow eligibility criteria for opening a moratorium. You need greater confidence that the procedure will succeed before you start it than the level of confidence that you need for opening an administration appointment. And the criteria for success are more tightly drawn. It's a smaller target than it is for an administration. So there's a lot of cases that are suitable for administration, and only a very small subset of those cases where it's going to be legitimate to use moratorium instead. And then there's also the practitioner risk as well. The moratorium is a debtor in possession procedure, and there is going to be, I think, the risk of moratorium busting litigation, where creditors, other stakeholders who are aggrieved by the way that the moratorium is being used by the directors will actually be looking at closing it down. So I think there is a potentially a greater area of risk for you as insolvency practitioner in charge of a moratorium than going into administration. Second alternative that you might be thinking of would be a non-trading administration. Tried and tested, relatively safe. You get yourself appointed and you either close and mothball the business and you sell it in a few months' time when things are more suitable, or you go for the old-fashioned traditional pre-pack procedure. Either of those are possible. Third option is a pre-appointment administration moratorium. I haven't used these very often, but very occasionally they have been a useful way of holding everything together in the run-up to another procedure. It's been a CVA that we're trying to put together in these circumstances. And I think one use of the protocol template outside an administration itself might be as a way of defining interim powers for directors in a pre-appointment moratorium of that sort. So you actually get the directors voluntarily to limit what they're going to be dealing with, how they're going to be running the business, and for them to be reporting informally to you and consulting you about what they're doing in that period of time. And I think that might actually make things safer for directors in a situation like that than would otherwise be the case. It seems to me to be a big hole in the insolvency legislation at present, that we have got the ability to throw a pre-appointment moratorium before an administrator is appointed, to throw that moratorium around the company. And there's very, very little restriction on what directors can do in that period, and very little regulation of that. So I think, as I say, I think that the light touch protocol might be a useful template to help to control those situations a little better. Similarly, on a less formal basis, a CVA may be an alternative as well. And again, before the CVA is formally proposed to creditors, before it's approved, you might use the protocol as a way of actually defining the director's powers, of limiting the scope of what the company is doing, and effectively protecting the directors pre-appointment. Now, I think I have now covered all of the points that I intended to. I've gone on for 5 minutes longer than I intended, so I do apologise for that. I don't see any questions at the moment. If anybody has any questions, I'd invite them to raise them now. And in that case, I will simply say to all of you, thank you for participating. I hope you found this useful, and I hope you will join me again in a month's time on the 8th of February, talking about the next in these series, and we'll be doing what is a compare and contrast of the Companies Act misfeasance claims as against Insolvency Act statutory claims. Thank you all very much.